part 2. Just finishing off a little bit more on this. So that's what the commercial object of the agreement approach is applied. A couple of other things is that a clause that has more than one possible meaning is not void for uncertainty as long as the court can determine what its meaning is based on its proper construction and application. Now, uncertain terms, parties to a contract can sometimes use vague and uncertain terms. Now, judges will try and overcome such deficiencies if they can. They don't want to be the destroyer of bargains. Okay? But if they can't, then the contract may be declared void for lack of certainty, especially if it's a very important term. And whereas meaningless terms may often be ignored while still leaving the contract in place, the judge may sever the meaningless clause provided the clause doesn't form the basis of the contract. However, if it does form the basis of the contract, then it can't be severed and the contract will be void. So I think when we looked at when we talked about when you did that exam and you looked at terms, which you may have written, you don't want to write two things in a contract which may be conflicting because it creates uncertainty. Okay, which can then undermine the contract, or maybe a section of the contract. So that's why we don't want to write the same, slightly different things twice. We just write it once. Now we also have legislation in this area, which in many respects has what happens here is contracts is very common law based. And contractual law principles are largely created by precedent, as far as contract law is concerned. But from time to time, Parliament, which can override the common law, may step in and say, move over common law. These principles now apply. And section 23 to 27 of the Australian consumer law are examples of this. And I just want to go through this with you. Okay, I'm not going to try not to go through the legislation section by section because it's not the most riveting thing to do. And also I don't want to see your eyes glazing over. Okay, but the starting point is really section 23 of the Australian consumer law. And section 23, really we need to look at the definition of a consumer contract and a small business contract. And a consumer contract is defined as a contract for the supply of goods or services, or one that's for the sale or grant of an interest in land, which is to an individual acquiring predominantly for personal, domestic or household use. Okay. Now, a small business contract in that section is also defined as a contract for the supply of goods or services, or a sale or grant of an interest in land, and either a contract with an upfront price under the contract that's not more than $300,000, or a contract over a 12-month period with a price not over $1 million. Now, if a contract falls into those two definitions, okay, then terms in such contracts are void, and void means unenforceable, if A, the term is unfair. And what does unfair mean? Well, to look at what unfair means, we need to look at sections 24 and section 25. So let's have a look at section 24 of the Act. And it says a term of a consumer contract is unfair if it would cause a significant imbalance in the parties' rights and obligations arising under the contract, and it's not reasonably necessary in order to protect the legitimate interests of the party who would be advantaged by the term, and it would cause detriment to a party if it were to be applied or relied on. And number 2, we've got in determining whether the term of a consumer contract is unfair under subsection 1, a court may take into account such matters as it thinks relevant, but must take into account the following: the extent to which the term is transparent, it goes on, the contract as a whole, the The term is transparent if the term is expressed in a reasonably plain language, legible, presented clearly. And Section 5, we've got examples of unfair terms. Now, you'll see a pattern here in Section 25, okay? And under A, we've got a term that permits one party but not another party to avoid or limit performance of the contract. A term that permits one party but not the other to terminate the contract. These are examples here. A term that permits one party but not the other for a breach or termination of the contract. One party but not another to vary the terms of the contract. One party but not another to renew or not renew the contract. And so on and so on. Okay, various different examples. Those examples, basically, one party able to do something, the other not. Okay, so there's definitely an imbalance there. Okay, so, and you'll see on this, so if Section 24 and Section 25 examples are relevant, so if the term is unfair and the contract is a standard form contract, then the term could be void. Okay, and then we need to look at Section 27 of the Australian Consumer Law. And essentially, if it's alleged that it's a standard form contract, the court will presume it is. But the court has to take into account whether one party has all or most of the bargaining power, whether the contract was prepared by one party before the discussions, where the party is required to either accept or reject the contract terms. You know, was there an effective opportunity to negotiate? And usually with these standard form contracts, it's not. We use that contract, you accept it or reject it, or we don't go ahead. So essentially what this means is that if one party is using a standard form contract, and particularly if the terms in that contract are unfair, it's imbalanced, okay, then the Australian consumer law can come in and say, not enforceable. So essentially, we just need to be aware of the legislation there, which can come in, particularly when we use standard form contracts. In most situations, particularly where the standard form contract is prepared by an industry, for example, usually the industry association, for example, many associations, because they are aware of principles like this, they won't be drafting standard contracts which are going to actually breach it. Okay?
Has that happened in the past, though, that there were terms in either the AIPSA or the RESA contract that were overturned as being unfair?
Well, not under this legislation, because it's only come in, relatively recently. But I'm quite sure that in the past there has been criticism of terms. Absolutely, because ultimately, they use when they're drafted, they are quite often going to have their members in mind when they draft it. But this is really going a second level. This is really saying when it's obviously one-sided, okay, it's not going to be allowed. And the other thing with this is that it's more likely to occur. Well, in my view, I would say it's more likely to occur when you have small contract providers who are preparing their own contracts from scratch and who aren't familiar with this legislation. Okay, because they may think, oh, the beauty of contract law, we can agree anything, which is true as long as it's not illegal. And so, we'll make the contracts more one-sided for us. Okay, and that's all we deal with because we've got a superior bargaining position, and who else are you going to deal with, mate? And so if they then, in those type of situations, they then produce a contract that's in danger of being one-sided in this regard, then if action is brought, then the term will not be enforceable. All right.
So they're not giving the person the option to get to independent advice or legal advice on that contract. They're saying it's more like a coercion where he goes job.
That's it. I mean, they may take it or leave it contract.
Yeah.
I mean, they may. If they're smart, they'll go and get legal advice, and the legal advice which they'll get will say, don't enter that with a barge pole, it's too one-sided. Yeah. But essentially, you may have a later argument that the party has acted unconscionably, but that's a separate argument to the actual terms in the contract. Right. You're still awake on me or not?
Yeah.
Yep? Okay.
I've been through that with the solar farm. Signed a lease on them wanting to use our land. And I brought a caveat in today if anybody wants to have a look at it.
All right, very good. And did you review the contract that you?
Yeah, I went through it, sent back to him issues that I saw. A friend who's a solicitor, he looked at it and pointed out some things I didn't. But there were terms in there like if there was any damage done to the solar panels and that weren't their fault, it was then our fault, and they didn't have to pay rent for the period of however long it would take for the cost of getting them repaired and that. And I said, well, hang on, what if I haven't damaged them and somebody's shooting across the road or throwing rocks or something and they've damaged it, or hailstorm and that. So I highlighted that and said, no, I will only be held responsible for the damage I do, not for anything else, because I'm not going to be going in there, so I won't be doing any damage.
So they were essentially putting all the responsibility onto you, and if you hadn't actually brought that up, they would have been happy to have signed it. And issues like that, really, it'd be interesting to see in your contract, matters of insurance, whose obligation was to pay for insurance and things like that.
That's all there.
Yeah.
The only other thing is, we can't sell the land, why would you sell a passive income? So that's the caveat on it.
Okay. All right. Very good. Now, while we're on that, we've just finished. We're just basically talking about standard form contracts. So that's where legislation can come in. But we also need to understand some of the benefits of standard form contracts. Okay. Particularly when you're working in an industry, some of the benefits that are there. And if you've already got a pre-written standard form contract, then the benefits of that should be fairly obvious, shouldn't they? One is what? What benefits do you see? Speed, thank you. Speed. It's not going to take you a week to write up a contract for the particular matter that you're dealing with. You can do it quickly. And because of that, another benefit from that whole point is what?
It's already been noted out.
Yep. So we'll come back to that in a moment. But if it's speedy, it reduces the cost. Thank you. So it's going to be cheap, isn't it? It's already prepared. It's going to be quick to do, cheap. And you just said it's already been nutted out. Well, usually it's going to be prepared. These contracts are going to be prepared by professionals. So you can hope and expect that if it's produced by professionals who deal in that area, then the quality of that contract is going to be much stronger. So there may be less issues that are likely to arise because the contract is proven and tested, hopefully. Does that make sense? Okay. From your perspective also, if you're using the same contract every day, what does that do for you? Let's spread the love, guys.
Fill up quickly.
But you become familiar with it, you're going to be able to fill it out quickly. If I raise an issue with you, I'm a member of the public, and I don't understand this.
You have to explain it.
You should be able to explain it because you've used it many times before. So what's that going to do for you as a professional?
Make you look more professional.
It is, isn't it? And it's also going to raise your confidence, and then you know what you're doing. You're talking, so it's going to raise your professionalism by using that. Okay, so standard form contracts can be very, very useful. Okay, very cheap, very quick, and you're not reinventing the wheel all the time. Okay. So on that, now I'd like to do a little exercise with you. On the back of one of the handouts. Thank you. I didn't mean an aerobics class at that point. I just want to make that very clear. A little exercise with you. Now, I want you to prepare. I've got a little exercise for you, and I'm just going to read it out. The purchaser is concerned about white ants, and the vendor has agreed that a condition to cover that can be put in the contract. You have been asked to draft such a condition by the vendor. Prepare the condition. Now, in one of the handouts I've given you today on the back page, now in your exam, for example, you prepared contracts, but you didn't actually have a go at drafting a special condition. What I'd like you to do on those brief facts that you've got is just try and write a special condition starting in the middle of the page. or a third the way down the page. So, have a go at preparing a special condition based on those brief instructions.
Clarify, is the purchaser wanted it, right? Are we working for the purchaser or for the vendor?
No. You can say you're working for the vendor. I don't mind at this stage, but the vendor's agreed to it. So you need to have a go at drafting a special condition based on the instructions that you've got in that exercise.
Not for an inspection, but actual.
Yeah. The purchaser is concerned that the white ants and the vendor has agreed that as conditions that to cover that can be put in the contract. You have been asked to draft such a condition to the contract by the vendor. Prepare the condition.
So where is that? I've got a piece of paper.
Yeah, where is it? It's on the bottom of.
Okay, so everybody's had a go at this. Okay. Now, special conditions are potentially dangerous. Okay, but what we can also sometimes use is actually use some word synonyms to help us when we're actually drafting them. And the one that I use, which I made up a number of years ago, is the word synonym backpest. B is for bridge, C is for cost, P is for party, P is for price, E is for event, S is for standard, and T is for time. So what we can do when we've prepared a special condition, is we can usually write this little word synonym above our special condition which we've drafted and see if we've covered everything. And not all of these things will necessarily apply.
What does it stand for again? I can't see it. Standard?
Standard, yeah.
Thank you.
Okay. They may not all necessarily apply, but breach, B for breach. Okay. What happens if it's not done? Okay. C for cost. Who's paying? Okay. P for party. Who has to do something? Okay. P for price. Is there a price involved? Event. What's to be done? Okay. S for standard. What's the standard expected? And T, the time. Okay. So what I'd like you to do now is just above your special condition you've drafted, I want you to put BACPPEST and just check to see if you've covered them. If you have, put a little arrow and tick it off. Okay? So have a look at what you've done now and just check it. Okay? And see how many of them, not all of them may be relevant, okay? But just see if any of them you've covered, which ones you may have covered. Okay? And just self-check yourself there.
So what terms is standard?
Well, is there a standard that's expected?
Cost and the price. What's the difference?
There may not be any difference.
Okay.
Sometimes one may not be there, but sometimes there may be a price that's involved in whatever you're drafting. They may not all be relevant, but just self-check to see if they're relevant to your special condition, if you've covered them.
The second P base. The second P base.
Bridge?
The second P.
No, it's an A. It's just a link. It's just a link. Backpest.
P and place.
Right. So just check now and see how many you can tick off on what you drafted. Right. Two. That's all right. It's probably if you haven't got many, it's probably quite a good little exercise because then you can see what you missed. Okay. And I'm just going to give you an example. I'm just going to put up a draft example one, and we're going to have a chat about it. Okay.
What's the first word on number 3?
I've got to go through it with you in a moment, so... Okay, now, I've prepared a basic special condition. Okay. Now, put your pens down for a moment. Okay, this is more important. Okay, what I want you to just do with me. Okay. Now, it's a basic special condition which we're just going to now have a little go at checking to see if we can satisfy this little word synonym. Okay. So the first one we had was B for breach. Okay? Now, does it cover if something isn't done?
Yes, if the report's not satisfactory.
Yeah? So B is for breach. If this isn't done, or say this event isn't done, we'll come back to that in a moment perhaps. What about cost? Is cost relevant?
Yes.
Yes.
Where is cost detailed? Number 2, is it?
Yeah.
So we can go cost and we can tick it, yes?
Yep.
Now, What about the party? Who's to do something?
The purchaser.
The purchaser. The purchaser obtaining. So, can we tick that one off?
Yeah.
That one? Yeah. Is price relevant here in this one?
No, because you got
Well,
costs.
it's the same.
Doesn't appear to be relevant, does it? We don't have to worry about that one. What about event? Is it covering what the event is?
Yeah.
Yeah.
What-
And by date,
What is the event?
obtain.
Pest control.
Obtaining a what?
This
Pest
a
control.
report.
Satisfactory
Report. Okay, so we've got the event, haven't we?
Yeah.
Now, has standard been met in this example?
What do you class as standard?
Well,
Yeah.
what standard are we looking at? Is there a standard that's addressed in this basic special condition?
That it needs to be satisfied.
Okay, and does it? What's the criteria
Number
for
3,
satisfaction?
deemed satisfactory if it indicates there are no white ants.
Okay, so it looks like, so I'll just read through it. This contract is subject to the purchaser obtaining a satisfactory report from a pest controller. This report shall be 1, obtained by date, 2, at the cost of the purchaser, 3, deemed satisfactory if it indicates there are no white ants present on the property. If the report is not satisfactory, then the purchaser may terminate the contract pursuant to clause whatever. If the report is not obtained, then the vendor may treat this contract as unconditional so far as this special condition is concerned. Okay? So that's the basic term. So we've got standard, if it's not deemed satisfactory. Time, have we put a time frame on this?
Yes.
Yeah, obtained
Obtained
by.
date.
We have?
Yeah.
Okay. If something isn't done, and there's a breach of this clause, have we covered that?
Yes.
Where have we covered
Where?
that?
If the report is not obtained, then the vendor may treat this contract as unconditional
Okay.
so far as the
Okay.
special conditions are
Yeah.
concerned.
So, at first, when we look at this, it appears to have covered the basic things. Would we agree?
Yes.
Okay. Now, here's one thing about special conditions I want you to now think about at another level. Okay. Quite often, people can pick at them. If we don't draft them properly, we can pick at them, right? And we can pick at this example. Okay. For example, a satisfactory report. What might we say about the report? Yeah, I'll give you a report, mate. Yeah, get me on the blower. Yeah, no drama, mate. That's fine. Just like I kicked the tyres, it's fine. What would we say about the report, could we say? Which isn't actually drafted there.
There are no white ants.
By a qualified person,
Well,
really.
like pest-
Huh?
A pest
Just the
control.
report moment. Is that the form of the report? The
It doesn't
moment.
say whether it's
Satisfactory.
verbal or written or...
It could be verbal, couldn't it?
Yeah.
So we're probably are going to want a
Written.
written.
Yeah.
We're going to want a written. Okay. Now, pest controller.
License, do you have license?
Yeah.
License?
License.
Licensed pest controller. At the moment, we've just got pest controller, but
Is that something need a license?
a license.
Yeah, anyway.
Now, going on that, so I think you're spot on. License, it should be licensed, shouldn't it?
Yeah.
However, I'm just going to take it to another level. Yeah, guys, I'm licensed. I'm a licensed pest controller in Uzbekistan. Oh, Australian. Or even better,
Local.
an SA licensed pest controller. So what I'm trying to say is we can pick at them. Now, another thing I want you to just have another thing to look at. I'm just going to give you part of an extract from the RESA contract that's on the Learn side. Okay? And now, let's say this clause, this basic clause that we're drafting, okay, is being used in the RESA. In the RESA contract. Now,
Smart move.
at the end of the day, it doesn't matter about the clause itself. It's what you learn from this. Now, let's say, for example, this was used with the RESA contract. Say you drafted this using the RESA contract.
Yeah.
Now, we've got, the report shall be deemed satisfactory if it indicates there are no white ants present on the property. Okay. On the property. Now, in the RESA contract, how is the property defined? Let's have a look at it. Come on. Look in your contract. If we were using this with the RESA contract, let's now look at is the property defined?
The land, the whole of, part of, land, certificate, volume.
So, James, what clause are we looking? Where do we find the definition of the property?
Well, you've got to put in number 4.
No, we want the terms and conditions of the contract, not the schedule.
Oh, okay.
Is there a definition of a property?
Yes, 2.1.17.
2.1.17. And hold on, Martha. Now, so what does that definition say, Martha?
It says property means the land specified in item 4 of the schedule together with A, the easements, rights, privileges and appurtenances referred to on the certificate of title or form 1 and any improvements and fixtures and fittings and the included chattels.
Thank you. So it says the land specified in item 4 of the schedule plus those things. Item 4 of the schedule, what would normally be put in item 4 of the schedule?
Information from the certificate of title.
The information from the certificate of title. So usually it's going to be the whole of the land and certificate of title number, isn't it?
Yeah.
Okay, now I'll put something to you. I'm the vendor of the property. The report comes back and it says there are white ants on the fences of the property. And the fence happens to be 200 yards away from the house. The purchaser turns round and says, "Oh, white ants. Oh, it's on the fence. Oh, I have doubts about that property. Oh, it's got me worried. No, I'm not going through with it."
I wouldn't like it either.
But you're acting for the vendor. And what does the vendor say?
Can get them treated, they're on the house, they're on structures.
Yeah, we have
Okay,
that
but as far as this clause is concerned, can the purchaser get out of the deal?
Yes.
Yes, they can. Let's be honest. If you've got a paddock that's 200 yards long, probably in most blocks in Adelaide, somewhere on that property, 200 yards away from the house, you're probably going to have a few white ants. Okay? But what do you think the intent of the purge of this special condition probably was?
To make sure that what you're buying, like the house itself, isn't structurally damaged.
The house itself. Do you agree with me?
Yes.
If would you think normally that when you're putting this special condition, it's actually the main dwelling or the building or the house?
But
It's
that
not
wouldn't
really
have been
about...
the purchaser's intention, though. It would have been the vendor's, but not the purchaser's intention.
Well, possibly. I don't know what the intent of the parties is, but most people would normally think that the special condition would probably be put in because it's about the house, which is the main value
House or sheds.
on the property, isn't it?
Yeah.
Not necessarily a fence which could be 100 yards, 200 yards away. But it doesn't matter what our intention is because the way this is currently written, it means that the purchaser could get out of the contract because
The fence is in the property, it's within there.
it's within the land type, it's within the
Yeah.
certificate of title,
Yeah.
and so they'd be able to get out.
Yeah.
So what I'm saying now is
Be specific about it.
we've got to be very specific, and we've also got to be importantly, we've also got to be very careful to consider what contract we're putting it into to make sure that our intentions in the special condition match with what any definitions may be in that particular contract. You still with me?
Yeah.
Okay. So, I would presume, you can argue this with me, Julie, I don't mind, okay? That if we were to, we'd have to amend this special condition, we're acting for the vendor, and we would probably be saying, present on the...
Property.
No.
Dwelling.
Buildings.
Put a sign on the...
Buildings.
On the
buildings.
main dwelling
Dwelling,
on
Sheds.
the property. And if you wanted to, you could put in brackets house, shed. You could be more specific. Buildings, whatever, you could do that. But what I'm really trying to say here is that on first instance, that special condition that we drafted looked okay. It looked like it's covered the basics that we needed to do.
Okay.
And so we can get to that first level by using the word synonym, okay, to self-check what we actually prepared. But then, when you actually go back to it, you can start picking, and people can pick. And if you're using it in a standard contract, you have to check what contract you're using to make sure it doesn't clash or there's no problem there.
Yeah.
So this doesn't clash with.
So if I pick some more, so does it need to say, or should it say, a report is not obtained for any reason whatsoever? Because, say you use your test endeavours and the pest controller got it to you a day late, and it did have white ants in the house. Then could they argue, well, it was obtained, they just sent it a little bit late. So does it need to say for any reason whatsoever, or not?
No, because we've set a date that it has to be obtained. But what you might say about the report, at the moment there's just going to be a written report. But what we could also add to this clause is say a copy of this written report has to be provided to the vendor, okay, by a certain date as well.
Does that always mean the end of, or should you put by the end of?
Well, normally, if you say by the 5th of September, you'd expect it to be delivered by midnight on the 5th of September. That would be
So that's accepted by the end of that date, yeah.
Normally you'd think that, but there's no reason why you can't define, a particular date if necessary. Okay,
So you don't say close of business, you go to the midnight, do you?
Well, you could, but you could say close of business on the 5th if you
But
wanted
you're not
to.
going to be checking your emails or whatever at midnight.
But it really comes down, if you've given a date, as long as it's, if you've received acknowledgement by that date, then you should be fine. But at the end of the day, we're not going to get worked up about the dates for the moment because we're really addressing that here, okay? But we can pick with special conditions. Now, I've got some suggestions I want to give you, okay? So have your pen handy, and these are...
Oh, is that podcast all right?
Yes, thank you, yes. Yeah, thank you. These are some suggestions. Okay. Suggestions re special conditions. Number one. These are suggestions. So put a heading, suggestions. Number one. Number one is, don't write them at all if you can help it. And I will clarify that in a moment. Don't write them at all if you can help it or you can get away with it. Dash. Okay. Dash. Use the cooling off period and the weekend. What's he talking about? Okay, I will elaborate. The purchaser wants it to be subject to white ants. Vendor says, I've got no problem you inspecting the property for white ants. I don't want to put a special condition in. You've got the weekend, you've got cooling off. I'm happy for you to have somebody come round and check the property in that period.
So you don't have to have it in writing.
Then you don't have to write a special condition. You give them permission that they can come round over the weekend during the cooling off and they can check it to their heart's content.
But then what if they renege and they don't give you key or access?
Well, then they've breached the verbal agreement. So you might, you might put in as an additional term that access will be granted if necessary to do that. But it's usually the vendor isn't going to stop doing that because they want the purchaser. If the vendor's actually wants the sale, they're not going to obstruct the purchaser from entering because the purchaser can call off anyway. Okay. Number two. If you are not comfortable in drafting them, Don't do it. Get someone else. Bless you. Who is more specialised to do it. In your profession, after a few years, I suspect you will be very competent in most areas, but there may be certain areas you're not happy with. No, I've got to be honest, I'm bloody brilliant at doing that. I'm bloody fantastic at doing that. But these special conditions, oh my word, it's a nightmare. Am I going to draft them? No siree. I've got so-and-so in the office and that's all he or she does every day. I'll ask them to do it. Or if it's really, really difficult, I'll say to the client, look, this is a special condition that you need here. You really need to get a specialist to do it. It's quite difficult, etc., etc. But on basic level, if from a pure risk perspective, if you're not happy or comfortable in drafting them, don't do it. Because if you stuff up, the risk is on you. Okay? But this is where professional judgment comes in. Number three. Try and keep them concise where possible. Now, some people, they love drafting special conditions. Oh, they get a real kick out of it. Oh, it's a lot. It's almost like hearing. Some people like to hear the sound of their own voice. Well, some people, when they get into drafting special conditions, like to see that the sound of their own writing. Isn't that fancy? Isn't that good? That sounds really good. I'm impressing myself here. That's so fancy. Look what we did with a special condition, a basic special condition, which really is 2 paragraphs. We picked at it, and we found issues. It's an old saying. You give a person a long enough rope, they'll hang themselves. Okay? So, if you're going to use them, try and keep it as concise as possible. Okay?
The other one is give them an inch, they'll take a mile.
Well, that's not... Now, the next one. Number 4. Okay, number 4. Actually, I'll just give you an example on the concise one. When I was in practice, special conditions wills are another area where it's some very similar principles in here. And I remember my boss, he had a client come in, and it was drafting a will, and he got the client, and he basically was putting all these connotations. If you get bankrupt, this will happen. If you don't get bankrupt, that will happen. And all these fancy little issues, alternatives. And I remember he talked all this into the client, and then he shoved the work onto me. Right? So I had to deal with the issues then which raised. And the problem with wills, and it was at a certain extent, and you'll be able to talk about this more than me, is that if you make a mistake in the drafting and a trust or a gift fails, and so on and so forth, it can be an absolute nightmare. Right? And so consequently, I remember sitting at the desk realising all these different connotations and seeing all the problems, and after a few days I realised, I'm not doing it. So I had to get the client back in and take new instructions and give them my advice and do it much simpler. But if I tried to do it how my boss wanted it, was advising him to be done, I was basically putting myself at risk in some of the connotations which could apply. It was a simple, keep them simple. We'll always keep them simple. Simple language, and not overdo it. Number 4, moving off track a little bit. Number 4.
I thought you were only a conveyancer and not a lawyer. Were you a lawyer as well?
Yes.
I'm not a conveyancer.
Somebody told me. I thought somebody told me ago that you were a conveyancer and not a lawyer. You're a lawyer.
No, that's right.
Oh, sorry.
Okay.
Good to know.
Now, next one. Number 4, get someone else to check it afterwards. Get someone else to check it afterwards. Now, this can be really important. Okay. I used to work in an office with a guy. He handled the firm's debt collection, and he used to be a major in the army. And I used to laugh my head off because he'd be forever pretending he was somebody from a pub. He'd be putting on accents all the time, trying to find somebody so he could then go and serve summonses on them, pretending to be someone else. And his favourite was always, I owe you some money. It's Jimmy from the pub, and I owe you some money. Are you going to be at the pub on 2 o'clock this afternoon? Because I need to give this money back. I've not been able to sleep because I owe this money and all this sort of stuff. So, yeah. To serve them and so on. Yeah. Oh, he used to pull every trick in the book, and it was quite amusing to listen to. Now, one thing which we would often do is he'd have to draft different things, and I would have to draft different things, and quite often we would work as a tandem. Okay, you'd prepare your draft, and sometimes there's another old saying. I like these old sayings. Sometimes you can't see the wood for the trees. I draft my special condition. Oh, that looks fantastic. Yeah. Right? You give it to somebody else to look at, and I'd be doing the same to him. I'd get him to look at it, and he'd say, well, what's happening there? And initially you can get very defensive, say, oh no, that works out really well. And then you read it, and you think about it again, and suddenly, oh, hold on a minute. Exactly. How did I miss that? Because a fresh pair of eyes sees it. And the number of times he helped me and I helped him, it really can help. Okay? Next one, number 5. Okay, number 5. If you use a precedent, make sure it fits. Okay? I.e., it's internally consistent with the contract you are inserting it into.
Can you start that little bit again, please?
Yep. If you use a precedent, make sure it fits, i.e., it's internally consistent with the contract you are inserting it into. Check, e.g., check definitions, clauses.